Good afternoon, everyone. My name is Dave Marusars. I'm the rookie staff attorney over at the DLGF, and I'll be giving a brief review of property tax exemptions. As always, we will have the PowerPoint presentation available on the DLGF website, and in fact, I believe today it's already available for your reference. Here are the topics that we'll be covering. There are quite a few subjects, but I will try to speed along and keep this presentation as short as possible. Before we begin, I'll have to give you my obligatory disclaimer. This presentation is not a substitute for reading the law. Now, speaking of laws, and to show that I am very bad at transitions, discussing the legal basis for exemptions, the first place is always, to start is always the Indiana State Constitution, which permits the legislature to exempt certain classes of property from taxation. The legislature must designate in statute the sorts of property available for exemption and to what extent the property is exempt. Now, the exemptions mostly are contained within Indiana Code 6-1.1-10, but you may find other exemptions throughout the code. And IC 6-1.1-11 contains the exemption procedures containing such things as application deadlines, application requirements, and so on. Now, an exemption is a privilege that a taxpayer who would be eligible for the exemption can waive. So, for example, a charity-owned property that would qualify for an exemption, but for whatever reason the charity did not file for the exemption or filed improperly. In that case, the property would not be exempt, and the charity is considered to have waived its privilege to the exemption. Furthermore, the burden is on the taxpayer to show a substantial relation of the property to an exempt purpose. In other words, it's not enough for a taxpayer to claim an exempt purpose. It must produce evidence that is indeed fulfilling that purpose. Moving right along, this is just a brief slide pointing out the legal distinction between exemptions, deductions, and credits. A summary of what those distinctions are on the slide. And essentially what this just means is, in terms of nomenclature, there's no such thing as a homestead exemption or an over 65 exemption. Deduction, exemption, and credit have distinct legal meanings that are not interchangeable. Getting more into the meat of the exemptions, a taxpayer wishing to apply for an exemption must file the Form 136 application with the county assessor on or before May 15th of the assessment year. However, property used and occupied of real property by a government unit does not require an application. Now, for government units, we're talking about the United States, the state of Indiana, an agency of the state, or a political subdivision, which is defined in the code as a municipal corporation or special taxing district, such things as counties, towns, townships, which are defined also in the Indiana Code. Now, generally, a Form 136 must be refiled every even year. There is, however, an exception for properties owned and used for religious, charitable, or fraternal purposes. In these cases, if the property had been receiving an exception under IC 6-1.1-10-16-21 or -24, and the application has been filed properly at least once, and the property continues to qualify for the exemption, then no refiling is necessary. Now, sorry? Certainly, sorry. Now, one question that may arise with respect to applications is why some properties are exempt from filing automatically while others need to file. The reason for this is that the Indiana Code distinguishes between properties exempt by law and one's properties exempt by filing. Properties exempt by law, which include government properties, do not require an application, while properties exempt by filing, including those owned, used, and occupied, if real property for purposes included in Indiana Code 6-1.1-10-16-21 or -24, those require an application and must receive approval before they are exempt. And you'll see the code site to which I'm referring to that explains this. Moving on to the next subject. In cases of changes in ownership or use, If the property continues to meet the requirements for purposes under charitable, religious, educational, fraternal, etc., in the statutes, then the exemption is valid. But if the property does not continue to meet the exemption requirements, such as by change to a non-exempt use, then the exemption is to be removed for the same tax cycle. Please note that this differs from how deductions are treated. Deductions stay on for the same for that tax cycle, for the entire tax cycle, even if property changes hands during the year, so long as the deductions were validly in place on March 1st. Now, another question that arises is, what if the ownership changes or the property is used for a non-exempt purpose? In this case, that the taxpayer must submit an affidavit notifying the county assessor that a change in ownership or use has occurred, and a link to the form affidavit is provided on the slide. Now, if a county assessor discovers that the title to the property has changed, the assessor must notify the persons who will receive the tax billing statement. This notice must indicate that the title to the property has changed and that the county auditor will suspend the exemption unless the assessor receives a signed affidavit identifying the new owners and indicating that the property continues to meet the requirements for the exemption. If, upon receiving the affidavit, the assessor must reinstate the exemption for the years for which the exemption was suspended. And the exemption is then to stay on for each year thereafter, so long as the property continues to meet the requirements for that exemption. Moving on, to grant an exemption, the county PETA must find that the statutory requirements have been met, taking into consideration the sorts of evidence that the taxpayer applicant provides to the PETA showing that they are eligible. Now, if the PETA determines that the statutory requirements have not been met, then the exemption cannot be granted, and the PETA must provide notice of denial via the Form 120 to the applicant. Upon receiving the Form 120 notice of denial, the applicant may appeal to the Indiana Board of Tax Review within 30 days after receiving that notice. Now, that is a statutory requirement, but I will point out that the Indiana Board of Tax Review website and rules following Indiana Code 6-1.1-15-3 state that an appeal may be filed within 45 days after receiving the notice. Moving along to some additional points regarding exemptions. Exemptions may include both real and personal property or either or. An exemption can be made on 100% of the property or a certain percentage based on the circumstances, and the taxpayer must submit evidence that the property qualifies for exemption under a specific statute. And failure to provide this evidence may result in denial of the exemption. What this means is that it's not enough for a taxpayer applicant to essentially state that they are a church or a charity or a fraternal organization or a brotherhood, and therefore that they're exempt. They have to show and provide evidence that they are satisfying some exempt purpose according to the statutory requirements. I would also like to point out to you Indiana Code 6-1.1-12-46. This was made into law in 2011. This statute was meant to give a taxpayer who acquired non-exempt property but then would be eligible for an exemption as much of a reduction in tax liability as possible, because the exemption would not be put on the property until the next assessment date. So, for example, a charity acquires non-exempt property but then files for an exemption within the deadline, and after which the PETA grants the exemption. Because the property was not exempt as of the assessment date on the year that the charity files for the exemption, the charity would not receive the benefit of the exemption until the next year's assessment date. Under this statute, if the property had deductions in place on March 1st of the year, those exemptions would stay on for the remainder of the year, as would the circuit breaker cap and other credits that the property may be receiving for that year. And on the next slide, we just have an example explaining the statute. In the interest of time, I won't go over it, but below you'll find a link to the memo from which this from which this example was derived. And like I said, the presentation, the PowerPoint is available on the DLGF website. Moving from the statutes more into case decisions, we'll review now the Oak and Bucket decision from 2010. The Hamilton County PETA BOA and Hamilton County Assessor versus Oak and Bucket Partners was a 2010 Indiana Supreme Court decision that that counties should take heed of when reviewing property tax exemption applications filed by landlords who rent to religious or charitable organizations. The quick facts of the case were that Oak and Bucket Partners was a for-profit company that rented part of its property out to a church at below market rent. Oak and Bucket then filed for an application, or for an exemption, excuse me, and was thereafter denied an exemption. Some of the key points of the case worth considering. The Supreme Court stated that for a landlord applying for an exemption in order to qualify, the landlord applicant must demonstrate that the property is owned, occupied, and predominantly used for exempt purposes. The court refers to this, if you will, as a unity of purpose. Now, when such unity is lacking, both the landlord applicant and tenant must demonstrate that they each possess their own independent exempt purpose. Now, the Supreme Court in this decision went on to say that while it may have been, it may have shown some beneficent motive on the part of the landlord applicant to allow the church to rent the property at below market rent, that in and of itself is insufficient to justify an exemption for the landlord applicant. And that more evidence is required to show that the landlord applicant has its own independent exempt purpose, independent, I should say, to that of the church or a charitable organization or an exempt entity. So what the case essentially boils down to is that charging below market rent to an exempt entity does not, without more, establish an exempt purpose on the part of the property owner. Like I said, the property owner or the landlord would have to show an exempt purpose independent to that of an exempt entity. Now, for the last part of our presentation, my part of the presentation, I'll go over the subject of exempting nursing homes. Now, over the last several years, there's been some debate brewing over whether nursing homes should be exempt. In February of 2012, the Indiana Tax Court rendered a decision involving the Tipton County Healthcare Foundation versus the Tipton County Assessor. By way of background, the facts of this case essentially were that the foundation owned an assisted living facility that it had leased to a for-profit company to manage and operate the facility. Now, the company, per its lease, had paid the foundation minimal rent, paid for expenses such as utilities, and also covered the property taxes. The foundation then applied for the exemption but was then denied. I would like to emphasize that while this decision is not necessarily controlling in all property exemption cases, the tax court made some important points worth considering. Now, the sole issue in this case was whether the foundation raised a prima facie case that its assisted living facility had met the requirements for a charitable purpose exemption. That is to say, did the foundation provide evidence to the county showing that it had its own independent exempt purpose? Now, the tax court had, in this decision, continued the legacy of Oak and Bucket, acknowledging that unity of purpose is not required by the Indiana Code, but it affirmed the Supreme Court's statement in Oak and Bucket that when the unity of purpose is lacking, both the lessor applicant and the lessee, that is to say landlord and tenant, must each demonstrate their own independent exempt purposes. The court also observed the long-established holding that exemption statutes are to be strictly construed against the taxpayer. Again, the taxpayer has the burden to prove its property exempt to the county. So to establish its qualification for a charitable purposes exemption, a taxpayer must show obviously charitable acts different from the everyday purposes and activities of man in general, which are manifest in the relief of a person's needs. Indeed, the court recognized that a charitable purpose is accomplished by meeting the needs of the aging, and as the quote on this slide indicates, the court emphasized the importance of charitable acts of a nursing home in answering the question of whether the nursing home should be exempt. However, the court went on to stress that good and noble deeds alone do not constitute a charitable purpose. The court stated that Indiana Code 6-1.1-10-16 requires the showing of a charitable purpose to ensure two things. First, that the benefit that the exemption confers will relieve government of a cost it would otherwise bear. That is to say, if the nursing home wasn't operating to care for the elderly, the government would have to step in and expend its own resources to meet that need. Secondly, a showing of a charitable purpose is required by statute to show that the exemption's largesse will not primarily fulfill a commercial profit motive. In other words, the taxpayer should not be benefiting from not paying property taxes while running a primarily for-profit operation. Moreover, a for-profit status, the court says, is pertinent, though not in itself sufficient to show a private benefit. In other words, the court recognizes that even if the taxpayer is a for-profit organization, it is possible for it to show that the lease arrangement it had is fulfilling a charitable purpose and not a profit motive. Now, the court here is simply just pointing out that more information is needed to determine eligibility. Kind of the last few points that the tax court made in its decision, in its opinion, the tax court stressed that while the tax court ruling is informative for when reviewing a property tax exemption for a nursing home, each situation stands on its own merits. The court stated that neither the language of one case nor an apparent trend from several cases has established a per se rule that an assisted living facility that cares for the elderly is automatically considered exempt by the mere character of its deeds. Indeed, for purposes of nursing home exemptions by nursing home, exemption applications from nursing homes, excuse me, I'm almost done, as well as just property tax exemption applications in general, the tax court in this case followed the existing principle that every exemption case stands on its own facts and therefore is not susceptible to bright line tests or other abbreviated inquiries. The counties are tasked with determining the eligibility of taxpayers for exemptions based on the evidence the taxpayers provide and the cases that they have made. And with that, that concludes my part of the presentation. Thank you all for your attention. I hope I was able to keep it as short as possible, and I will now turn over things to my colleague, Mike.